From Queen Direct to Sport Direct, why should regulators be better off than insurer when it comes to privilege document? In this article, Helen Evan and William Harman of 4 News Square argue that the recent decision in Financial Reporting Council Limited Sport Direct International reignites the debate about whether regulators should be better off than insurer when it comes to seeking privileged documents belonging to the client of professional that they regulate or insure. What did Queen Direct and Sport Direct decide? In last week's decision in Sport Direct, Arnold Chi held that the FRC was entitled to call for privileged document in the hand of the auditor's client even if that client didn't consent. By contrast, 7 years ago in Queen Direct Law Society, the Court of Appeal held the insurer were not entitled to see documents belonging to a solicitor client in circumstances where the client had not waived privilege. Is there a principal reason for this difference in approach? Although the outcomes were different, both Sport Direct and Queen Direct drew heavily on the speech of Lord Hoffman in R, Special Commissioner of Income Tax. Having reviewed the case law, much of which concerned the Law Society, he set out two alternative justifications for the principle that regulators may inspect documents held by a professional even though they are privileged in favor of the professional client. Firstly, Lord Hoffman suggested that there was in fact no infringement of the client privilege in circumstances where the regulator was not entitled to use information disclosed by the professional for any purpose other than the investigation. Secondly, he pointed out that if there was an infringement of privilege in the reported cases, it was limited and authorized by the statutory powers of the Law Society. His decision and the authorities reviewed in it provide an important part of the backdrop to both Queen Direct and Sport Direct. The decision in Queen Direct. In Queen Direct, the Court of Appeal had to consider whether a professional indemnity insurer was entitled to require the Law Society to produce privileged documents belonging to the solicitor client that might have a bearing on whether insurer could decline cover to the solicitor on ground of fraud. The Court of Appeal found that the insurer were not entitled to see the document. They rejected Quinn's argument that insurers should be part of what Lord Hoffman had called a circle of confidence for the purposes of seeing privileged material in Morgan Grenfell. They drew on Lord Hoffman's observation that privilege was a fundamental human right and stated that any claim that it should be relaxed should be subject to the greedy circumspection. The decision caused some controversy at the time. The Court of Appeal acknowledged that the consequence of it was what their former client had not waived privilege by making a claim. Solicitors were constrained in what they could tell their insurer about circumstances that might give rise to claim in future. The Court of Appeal went so far as to say that if the client will not waive his privilege to enable proper disclosure to be made, the consequence of the resulting conflict of interest will be that the insurance is vitiated or the notification inadequate, but that is the problem of the solicitor, not the client. The Court of Appeal treated the problem as a necessary side effect of protecting a client's privilege. Criticism of the decision included the fact that, for many types of cover, the client is likely to be the one who suffers if no insurance is in place. The Court of Appeal's decision was also criticized for placing too little weight on the public interest in having an appropriately insured solicitor provision, or the establishment of the minimum term and condition by the SRA in order to achieve that aim. The decision in Sport Direct. By contrast, in Sport Direct, the court held that the production of documents belonging to an auditor's client to the FRC for the purposes of a confidential investigation into the auditor was not an infringement of any legal professional privilege of the underlying client in respect of those documents. Arnold G. also relied heavily on the decision of Lord Hoffman in Morgan Grenfell, although he drew on the matter set out at para. Above rather that the part of the decision relied on the by the Court of the Appeal in Queen. Thank you.